Good afternoon, ladies and gentlemen. My name is Rizwan Desai, and as has been indicated, I'm a partner at Collins Newman & Company. And I have been fortunate enough to be involved in the last 3 IPOs that have been brought before the Botswana Stock Exchange: Wilderness Holdings, Choppies, and now yet to be, closed, but yet to be information collated and brought to the market, Botswana Telecommunications Corporation Limited, BTCL. Before I proceed, I think because this is a public forum, I think I need to provide confirmation that although Mr. Ram of Choppies indicated or spelled out my name, there was no payment proffered to him for that. But I think I can also make the disclosure that since he's been such a good sport, I will probably buy my basket of groceries at the Choppies store tonight. So it's my pleasure and privilege, of course, to be here this afternoon, as I say, to chair this august panel of listing experts. Ladies and gentlemen, before I introduce them, we have heard in the previous panel discussion from those gentlemen who in some shape or form, and I'm sure there'll be a lady to join them in due course to provide the gender equality. Those guys have reaped clearly the benefits of a listing. Thank you. On the BSE, and how such listing has fundamentally and essentially transformed their lives and the direction and scope of their respective companies. Now, what we are here today to share with you is that this process of a listing, does not operate in a vacuum. It does not take place automatically. It does not happen by itself. It is a highly technical and complex process involving a lot of coordinated and hard teamwork, and a number of essential players ranging from, as we've heard before in some of the previous discussions, the board and management of the company to be listed, the existing shareholders of the company, financial advisors, legal advisors, sponsoring brokers, transfer secretaries, and of course, the ultimate guiding hand, the Botswana Stock Exchange as the primary listings regulator. Put another way, ladies and gentlemen, a listing is put in motion and implemented by the advisory team, and Tametsi was clear that you do need to have an advisory team appointed by any given company wanting to come to the market to do so. So helping me and you unlock and demystify some of these key issues relating to the role of advisors are the persons who've been introduced: Max Mainelli, Sipho Ziga, Steve Pizarro, Osi Lemo, and Dr. Wala Chabala. And we hope that the composition of the panel will provide the requisite cross-section to give you an idea as to the kind of inputs that go into a listing. So the way I propose that this session proceeds, and I'm conscious here that there are persons in the audience who have a very sophisticated knowledge of how the stock exchange operates, but equally there are persons who, as we've heard, potentially entrepreneurs, Cerebello Express, maybe some others in the audience who may be thinking about this thing called a listing and how do we go about it. So I think the way I'm going to structure the questions to the panelists will be firstly to ask them to answer broadly in terms of the key components, and then if we have time perhaps to discuss some specialist considerations that can apply in the context of advisory work and certainly have applied in relation to the BTCL IPO, which is, as we all know in this room, very much in the news. I must emphasize on that last score that the offer has closed, but the listing has not yet happened. So we are in that interim period when a lot of work needs to be done, and therefore the disclosure of information at this stage is difficult. I can, however, correct Tametsi to say it's not 30,000, it's more than 30,000. So that's a spectacular achievement that we can share, but perhaps not much more than that. But with those few words, let me just maybe kick off with Max. Max, as a financial advisor, and that word covers a whole area of activities. What would you say to our audience today in terms of what are the core elements of the work that you do and the value that you provide to a listing process?
I think before I answer that question, Rizwan, just to understand that as a financial advisor, you're really there to support management and walk the path or the journey of the IPO. This can span over a long period of time. And depending on the maturity of the business, we've heard from the audience some sort of smaller companies that are aspiring to become listed on the board. Clearly, they may have a longer journey to an IPO as opposed to a mature business, a business that is well structured, has all the corporate governance structures in place that we've heard about earlier, and observes and has all the checks and balances in place. So really, the financial advisor, as well as the other members of the team that you described earlier, walk the journey with the company management and the sellers of the business or the owners of the business. So I think as a financial advisor, you need to have a real broad business experience. It helps to know the local business practices, to know what happens in the business, and really have done it before. You need some track record. You need to be credible. You need to be able to demonstrate to the investor that I know this person. I know he's worked in this team. I know this person or this team from my interactions in this market. So I do trust him. After all, you bring this product to the market, and it's the credibility in the market that you want. So you don't want to just have the experience. You also want to have the track record, and you want to be known to be an expert in that area. So I think that's the first thing. So really, what does this job entail? It entails getting management ready for the IPO, and readiness for the IPO is perhaps the most daunting thing, because management has to basically double up on their functions that they need to do for the day-to-day running of the business and concentrate all their efforts on this IPO, which as I said, can last between 50 weeks to years, getting the company ready for this IPO. So I think as a financial consultant, you need to understand the dynamic of the business. You need to really understand the company's business, because you've got to advise, you've got to challenge the business plans that have been brought before you for the concept to taking this company to an IPO. After all, when you go out to the market and you're ready with your prospectus out in the market, it's the very investors and the institutional investors who demand those answers. So if you're not ready to answer those questions, then questions have to be asked around whether, did you prepare yourself for this IPO? Is this a credible IPO? Are your structures ideal and appropriate to take this company to the market? How big is this market? How big is the company, and where do you want to play in the market? We've also heard different stages of listing, from a development capital to a main board listing. So I guess you asked what sort of functions you do. I mean, of course, as an advisor, the first thing you do, you look at the business and verify the plans. Make sure that the strategies are aligned to the structures of the business, and that they are long-term strategies. Investors are there to buy into your company for the long term. The history is a good indicator of where you've come from, how fast you have grown, the dynamicism of the business, and say a lot for the management of the business. But going forward, I think that's what the investors are more interested in. So I think, so we start by looking at the business, try and align, looking at the structures of the business, what components of the business are profitable or not, and start looking at structuring this business to be streamlined and ready for an IPO. That may mean disposing of non-profitable business sectors, or realigning sectors, or rationalizing businesses so that you bring a lean and mean structure to the market that is able to actualize return to the investors. And that's what they're looking for. And the return in terms of dividends as well as capital growth. So valuation is another thing. You've got to bring the company to the market, so you've got to price it appropriately. And I think the mistake management does often, and some advisors do, is to try and assign a value to a share, which is unrealistic. You must remember that the investors out there, and some more sophisticated, are going to take all the figures that you will disclose at some point in time, and they will carry out their own valuation of this business to determine whether they are going to invest into the business or not. So I think the credibility of the process, the credibility of the involvements and all these interactions you have alongside management out there are so important. So I guess as a financial advisor, really you go through this process and take the company to the final listing.
I think just as a follow-up question, and I think leading on from a question that emerged earlier, an observation was made earlier. I mean, if I'm, an entrepreneur and I come to you, and it seems to me that, what you've said is perhaps easily understood by the sophisticated investor or a company which is already a corporate. But if I'm an entrepreneur, and I think a lot of the audience would like to perhaps get some insight into this, and I come to you and I say to you, I want to list. I like this idea, but I have no knowledge. What are the, and Mr. Abdullah spoke earlier about the mindset change that is required. So taking those things into account, if I come to you as you are a financial advisor, and I say to you, Mr. Marinelli, what are the key things that I need to consider immediately in terms of not knowing much about the Botswana Stock Exchange at the time I come to see you?
So I think you heard from Mr. Abdullah. I mean, he indicated that process was a scary process because, I mean, you own your business. You've made your own decisions. You've run this business all along. And suddenly, you have your consultant out there that sort of says to you, you've got to now sort of support good practices. You've got to install good practices in your business. You've got to give up some of the power you have right now as the sole owner of this business. So I think that really is a wake-up call often because, businesses are very successful and generally when they aspire to a listing is they've got something that they believe they can put on the table for investors to look at. But often the side of it that is not well considered is what they have to give up or what a business owner has to give up or a chief executive of a business who could well be also a business owner now is faced with independence issues. You've got to separate your personal agendas with the agendas of the business. And you've got to look at possibly strengthening that management team. So the recognition that perhaps in structuring your business to position it for a listing, you need further support. And I think that's probably, to me, the biggest wake-up call for any entrepreneur who has run a good business. However, to take it to the next level, may need a technical partner, may need investors, will need investors who are going to be asking some very pressing questions of him and are going to challenge the strategies that he has, past and future strategies. And another aspect of it is that if you're in a competitive industry, you now have to disclose information that in the past you may not have been willing to do, in a good spirit of good governance and transparency.
Thank you. I mean, I think one of the things, I guess, that, initially has to be thought about is which particular market or which particular board, rather, of the Botswana Stock Exchange the relevant entity is suitable for. Sipho Ziga, as lead partner of Armstrong's and obviously involved in a number of listings over the years, what's your experience been in terms of the newcomer to the market? What's the role in your experience of a lawyer? How can a lawyer help even before we get to the complicated documentation stage?
Okay. The easy answer to that is that even the stock exchange rules recognize the critical role of the lawyer, because in any listing, at some point, the lawyer is going to have to sign off a document indicating that he has been involved in the listing and he has advised. But besides that, involving a lawyer comes at a very early stage of the listing. When a decision is taken to list, one of the first advisors a client would typically go and see is a lawyer. Because before you even think of making the application to the stock exchange for a listing, the company must be prepared for that listing. As a starting point, a lawyer would have to conduct a due diligence. First of all, look at the type of company it is. Is it a company that's suitable for listing? Is it up to date with its statutory records? Does it have a constitution which is suitable for what it wants to do? Under that heading, the lawyer then goes about the preparatory work. There may be some restructuring required, including if it's a group of companies, restructuring the companies. If the companies may have minority shareholders who would want to exit, arranging for that exit until such time that you have a company which is packaged for purposes of the listing. As a lawyer, you would be involved in advising all in that process. The next stage then goes on to the listing process itself, which can really be categorized into two main areas. The one is the disclosure requirements which are required for the prospectus that is issued to the public. The next is the process that you need to follow, because it is quite a lengthy process, quite convoluted, but the process is there for a reason. In terms of the listing requirements and the Companies Act, there are certain disclosure requirements that have to be made in a prospectus. Unlike if it's your own private company, you don't have to tell anyone anything about your company. But the moment you become a listed company, the law imposes an obligation on you to say everything about the company. The intention is to protect the public. We advise on those disclosure requirements. We advise on the disclosure requirements which are set out in the Companies Act and those that are set out in the listing requirements. We also advise in the process and take the clients through the process, because it is a process of submitting all the necessary documents until such time that you get approval. When the stock exchange is satisfied that you have followed the correct processes, you have got all the documentation in place, and that you have made all the adequate disclosures. The other critical decision that needs to be made, and that's usually made in conjunction with the lawyer, is what type of listing you want. It is not, it can be done in many ways. Mr. Mulai explained earlier that you could list by way of an ordinary IPO, you could list by way of an introduction, you could actually have a private placement first, and then an IPO for part of the shares. All that involves a lot of planning, a lot of structuring, and sometimes a lot of negotiation, especially if a listing is preceded by a private placing, negotiation with private placing investors who will invest a substantial number of shares. It also involves, you are required to underwrite a listing, for instance. There could be negotiations with the underwriter, and where we get involved is to prepare and assist in negotiating that underwriting agreement. Once the company is then ready for listing, you then have to go through the process of taking the board through the listing. Importantly, when you list the company, all the directors of the company are obliged to individually and collectively confirm the truthfulness of the facts that are in the prospectus. It is a heavy burden. And it has happened on a number of occasions where directors are a bit reluctant to sign the acknowledgements required for a listing, simply because they haven't been involved in the day-to-day running of the company. It is then up to us, usually with the rest of the team, to appear before the board of directors and take them through the listing, and take them through line by line the prospectus and say, this is why we're doing this and this is why we're stating this in the prospectus, to give them comfort for them to sign those acknowledgements. Once the prospectus and the acknowledgements and all the processes are followed, the company obviously lists. But that is not the end of the role of an attorney in a listing, because post-listing, you now need to handhold the company because it's a whole new ballgame after the listing. There are numerous ongoing continuous obligations of a listed company that need to be complied with. For a few months or even years after a listing, the listed company will still require an attorney to take them through the whole maze of regulation that the company becomes subject to.
Thank you, Sipho. Just as a follow-up to that, obviously what you've described is a relatively complex process. And presumably what you'd be saying to people out there as part of the advisory team as a whole is that the earlier you're contacted, the better.
Yes.
And that you get involved in presumably understanding the business of the entity which is intending to list. And that will help you undertake your role in its fullest form.
Yeah.
Steve, Sipo mentioned, effectively, and as did Max, the requirement really to get the board and management of the company ready. What, in your view, are the essential ingredients of that state of readiness? What needs to happen before, the company can say, even before we get to the level of prospectus, that the company's board and management is in sufficient shape to come to the market?
Thanks, Rizwan. I think one of the key issues which hasn't really been addressed here is the financial reporting aspect. If you own your own company, you'll probably get management accounts on a monthly basis. You look at the cash flow, you look at how much is in the bank or how much you owe the bank, and that's how you run your business. In a public environment, this information now has to be communicated to your shareholders and to the market as a whole. And the capacity within your organization to produce that information accurately and timeously and present it in a manner which is acceptable is an important leap for a lot of smaller companies that are looking to list. So I think capacity building within the financial reporting aspect of the business is an important one. From a board perspective, and it's been mentioned a couple of times before, especially for owner-manager type businesses, the concept of having independent directors on your board that you have to justify decisions to, or in fact, even before you get to make a decision, you have to justify a business case, argue why you should be going into a neighboring country or stopping this particular business activity, can be very, very frustrating. So it's very important to identify the kind of characteristics that you would like to see in those independent directors, those non-executives who are really going to be sitting there with hands on the handbrake, stopping you at every moment saying, why are you doing this? Explain. Are you sure? And you can't just go and say, well, here's a handful of people, let's just pick a name. It's a very important role, and it's important that you secure the right type of people for your board who understand your business, who are as passionate about it as you are, and who are going to be there for the long term. This isn't a quick sitting fee type of arrangement. They've got to be involved in the business from the point of view of understanding it, understanding the strategy, and working with the management of that company towards the future.
Thank you. In terms, continuing with this theme of, how does a company prepare itself for a listing? What are sort of the other market considerations that one should take into account? I'm thinking about other companies in the same sector. I'm thinking about timing. What would your comments be in regard to those two aspects?
Well, I think the rationale for listing may be different from various different perspectives. It may be that there is a particular requirement for additional capital. It might be that you wish to expand beyond the borders of the country in which you currently operate. It might be that there is an opportunity, a business opportunity to take over a competitor. So dependent on the nature of the transaction, that will drive timing, and also from the perspective of valuation, you may be more sensitive if you are in a situation where you've got a lot of debt and you're desperate for capital, you're overgeared. You might be in a position there where you're having to go on bended knees, look for investors to beef up the capital of the company, whereas if you've got a strong capital base already, no debt, you can be a little bit more aggressive in terms of the pricing and be a lot more confident about the value of your shares going forward. I think those would be the key issues.
Thank you. Osi, Lemo, as the MD of Stockbrokers Botswana, could you share with us what the role effectively is of a sponsoring broker? We heard Mr. Malai talk about the BSE requirement that they be a broker, but perhaps you can share some light as to why that is the case and what it is that you do.
Okay. Before I get to answering the question, I would like to emphasize that it's within the BSE's interest to ensure that all listing companies and applicants and listed companies satisfy the BSE listing requirements. So in order for them to have a degree of comfort in so far as the compliance of the listing, the BSE requires the company to appoint a sponsoring broker, which should be a member of a BSE. It could be any of the 4 brokerage firms, to assist the applicants with the initial application, listing application, and as well as the continuing obligation as a listed company. So the 3 main points that I've compiled as our role is to act as a liaison between the company and its advisors and the BSE to ensure compliance with the BSE statutory requirements. We also act as a liaison between the company and its advisors to ensure that the quality and the standards, the accuracy and the standard of its documentation are of a high standard. The third one is to market the transaction to potential investors, and which could be retail or institutional, in conjunction with the advisors and the arrangers of the roadshows.
As a follow-up question, obviously that's a mechanical and technical job, and it's a requirement of the BSE listings requirements. Is there some way that a stockbroker or a sponsoring broker can add additional value to the listings process, to the company that's intending to list, or to the advisory team as a whole?
Of course it can, because a stockbroking firm is an integral part of the listing process. It acts as a quality assurer of the list of the application, and we have improved availability and quality of data required to meet prudential requirements for investors to make informed investment decisions. And then we have also supported the public through awareness campaigns, as evidenced by the most recent BTCL IPO, through initiatives like road shows and presentations, and just the public knowledge about investing in shares. So that's the value that we bring to.
Thank you, Usi. Steve, let me come back to you. If someone opens a prospectus, we see all these relevant advisors, legal, financial, etc. We also see a reference to the transfer secretary. And in your role as transfer secretary to some of the large listings that have occurred, what have you done in terms of your daily activity, and what's the importance of the role of a transfer secretary?
Thanks, Rizwan. I think the role of the transfer secretary has evolved as the stock exchange has developed and moved on to electronic settlement. In the old days, everything was based on paper, and the transfer secretary essentially was the generator of the very valuable share certificate. Share certificates are very much yesterday's game. Everything is now on a dematerialized basis, where shares are held through the CSD, and our role is effectively limited to interacting between the company and the various shareholders with regard to corporate actions. Those take place initially at the IPO, when we actually process applications from members of the public and from institutions and provide that data, which eventually gets input into the CSDB. And thereafter, for every corporate action with regard to AGMs, sending out all the documentation to shareholders to allow them to vote. And importantly, for dividends, recording on the last date to register, which is the day in which you are entitled to participate in a dividend. We get the information from the CSD, who those shareholders are, and then we process that dividend by means of reference to the actual dividend that's been declared, the interest rates, the tax rates that may apply to each individual investor, and the various settlement requirements that the shareholder may have required in terms of either electronic settlement or settlement by way of check.
Thank you. Doctor, I've left you last deliberately, only on the basis that you spoke previously, so I wanted to give you a bit of a rest. But in terms of your previous role at the Securities Exchange Commission as a regulator, what could you share, perhaps one or two thoughts about your experiences in interacting with an advisory group in a company? What are, in your vast experience, some of the the pitfalls that should be avoided, and perhaps then on the flip side of the coin, some of the things that a company intending to list and its advisory group should do in order to ensure a smoother process, a regulatory process as possible.
Thank you. Let me start by saying that there are two aspects to a company that comes to the market. The one, obviously, is before coming to the market, certain requirements that should be fulfilled. And after it has come to the market, those ongoing requirements that need to be fulfilled. From a regulator point of view, and specifically talking to corporate governance, it is required that several aspects are put in place at the beginning. For instance, it's important that it's recognized that there are different key role players in a company that is a public company as opposed to a private company, obviously. For instance, some of these key role players would be, and they're very clearly defined. So shareholders is one category of key stakeholders. Another category is the board, and after the board, executive management. Let me just say that for both shareholders and the board, there are different types. For instance, there are different classes of shareholders. But it's important from a regulatory point of view that all shareholders are treated equally by the company, by the business. The board would require that the board it's sound, good corporate governance, that the board is comprised of majority independent, non-executive board members. The distinction between executive and non-executive board members is that executive board members are part of management, whereas non-executive are not part of management. But not all non-executive board members are independent. It's preferable that you have majority of independent, obviously bringing objectivity to deliberations of the board. And specifically, it's recommended that the chairperson of the board comes from the independent non-executive. Now, that's the different key role players. Some of the functions that need to be in place in the business, some of them we've already heard about, but specifically there needs to be a strategy that is approved by the board, usually developed by the management, that gives direction to the development of the business going into the future. And once the strategy is in place, there's obviously supposed to be performance monitoring. Now, there needs to be an indication of how this performance is going to be monitored, and that's prior, but obviously there's also the ongoing obligations, where then you have the reporting itself. And reporting entails not just financials periodically, whether it's financial updates every quarter, every half, or the full report at the end of the year, but specifically there also needs to be full, timelessly, and accurate disclosure of what is known as material information, material occurrences in the business. Now, material occurrences in the business will be such that they could have an impact, especially on the price, on the performance of the price of the business. This is a very critical aspect, and usually a lot of management board members stumble on this when they have information that ought to be disclosed to the public because it has material impact on the performance of the business, but trade on that business. Trading on information like that is usually called insider trading. Again, from a corporate governance point of view, all shareholders, in being treated equally and equitably, should have access to the same information at the same time as much as possible. In fact, not just shareholders, all key stakeholders. And those that have information that can have material impact on the business cannot trade on that information, and if they did, that is an infringement required, of applicable rules and can be a jailable offense.
Thank you. Sipo, can I just come back to you? Most people associate a listing with a document called a prospectus, but there are other documents. What are the other key documents that someone who's considering a listing needs to have in place in relation to the company itself?
Okay. For those of you who have seen prospectuses or who have an opportunity to, if you read the prospectus, you'll realize that somewhere in the prospectus, there are documents that are made available for inspection. For any investor to go and inspect in the event that they want more information. Usually you'll find that those documents will comprise things like the constitution of the company, even though it is also summarized in the constitution. If there are any placing agreements, if there are any material contracts that the company is involved in, if there are, there's an underwriting agreement, it will be part of those documents that are prepared. And obviously, there's a whole array of documents surrounding that, like the director's acknowledgements, the resolutions, the declarations by the directors, which go together with the prospectus to the stock exchange for approval.
Thank you. Now, sticking to the prospectus, again, I guess it's necessary to understand, of course, that all of this expertise comes at a price. So when one opens a prospectus, beg your pardon, when one opens a prospectus and you see typically in the section on costs, the costs of the advisory team take up a large portion. Max, perhaps unfairly to you, but what would you say to a person coming to you and saying, but my God, these costs are astronomical?
I think costs are always a problem. It's another area where someone who comes for a listing does not have an appreciation or understanding of what it entails. Again, it depends. Some listings are easier than others. Some businesses are more mature and ready for listing. So it depends on the period. I mean, as professionals, be it the legal team or the accountants or the financial advisors, by and large, it's based on the duration of time and based on some sort of hourly rate. But I mean, we do, we also have to consider the risk that is taken by the professionals in doing this kind of work. So that's kind of incorporated in the rates. However, I mean, you have the ability to negotiate a rate with your clients and with your advisors. And I don't know of any advisor who's never looked at a negotiation with a client for a price. So if you feel that the fees are what you perceive to be expensive, I think they can be motivated, but I think they can be negotiated.
Dare I say it, the fees are typically cheaper than that of a bank.
I agree.
Thank you, TPD, at least for being humorous about it. I couldn't resist. What was the other word Mr. Abdullah used? It can be painful if one looks at the relative levels of remuneration. Anyway, that's a discussion for another day. Well, there you have it, ladies and gentlemen. I guess it's a truism to say the role of advisors is to advise. But I think what we've sought to do in this session, and we'll open up for questions just now because we still have 10 minutes, is to show you, to give you some sort of flavor of the breadth and depth of the expertise required. Ultimately, the success of an IPO is dependent on the interaction of the advisory team with the client with the advisory team, and both of them with the, in this case, the Botswana Stock Exchange. It can be a trying process. It can be complex. It can be convoluted. It can be frustrating. But if you have the right team of advisors, and I'm not necessarily saying that the people up here are the right team. There are other experts in the audience whom no doubt will make themselves known to people in the tea breaks and lunch breaks and so on. But you have got to have advisors. As Max says, there is an inherent cost to a listing. What that cost will depend on the complexity of the listing. and the market, the board, Botswana Stock Exchange Board, on which you want to list, and the market that you're looking to attract. So let me end there and invite questions. If I can just ask people to identify themselves and then, direct a question to a relevant member of the panel. There's one up there in the front, and then the gentleman at the back there.
Hello. Yeah, I'm Sriram from Sunshine Property Group.
Yes, thank you.
Yeah. See, I was looking at at people, and they are all excited that they could make public issues and now take money from the people and expand their businesses. But we want more clarification about the costs involved, because the cost of a public issue as a percentage of issue, can we have any guideline on that? And the payments that we make to the brokers, to the underwriters, to the lawyers, to the auditors, and the printing of this prospectus and the fees that we pay to the stock exchanges. So as a percentage, how much would that probably be? 10%, 15% of the public issue? And the next thing I wanted to ask is about, once the public issue is made, a yearly fee might be charged by the auditors and by the company secretaries, the transfer secretaries, and we have the stock exchange fee, which we pay every year, I presume. So how much would that be on a yearly basis? And at what level is it really viable to make a public issue? Because the levels I see, 2.5 million you can make a public issue, or 5 million you can make a public issue. But at a level of 5 million, is it viable for a company to make a public issue? So you people are experienced in public issues. What would you consider as a level at which you should say, okay, 50 million is good enough to make a public issue or something? Thank you.
Okay, thank you. You've actually asked, I think, 3 questions there. I'll just respond to the last one, and then is your question directed to a particular panelist or to the panel as a whole? Okay, so let me just respond to your last one. I think the level at which you feel your company is, listable worthy is entirely a decision that you will have to take as the company in conjunction with your advisors. There's no magic formulation. It will depend on your company, it will depend on the market you're in, and I guess this is the underlying and essential point, that you will be helped by your advisors. But there's no omnibus solution that I can suggest would work, or formulation that would work. But with regard to your point on costs and so on, perhaps maybe, Sipho, you could answer the issue of cost as a whole, okay. And then Max, maybe you could look at responding to percentage.
Yes. I think Max summed it up very well when he spoke about the issue of cost. It is a difficult issue because most of us sell our time. And one listing will not take the same time as another listing. So the longer it takes, either because the pre-listing work is more, the more fees you're going to pay. But a prudent business before listing would naturally engage all the advisors and enter into engagement letters to agree on fees before the listing. Obviously, those engagement letters could have formulas based on how long, if it takes a longer time than anticipated, how much the advisor is going to take. But that question cannot be answered by a simple answer. It depends on many variables. But if a company engages its advisors right at the beginning and enters into an engagement letter to say how they're going to be determined, fees are never really an issue.
Max?
Thanks, Rizwan. You can't apply a percentage, really. I think if I take that in conjunction with the follow-up question that Rizwan answered regarding, is a 5 million listing, is it economical or is it reasonable? The earlier presentations sort of gave different levels of entry into the market. So I think it needs to be part of a management strategy. I don't think any business would go to a stock exchange with the intention of remaining a 5 million, listing. I think anyone going to a stock exchange goes there for a reason. We've heard about raising capital, about possibly creating platforms and credibility for expansions and so on. So I think you would have to have a reason for wanting to go on a junior board, if we can call it that, and then with understanding and strategies to actually grow out of the junior board, because that's how you're going to unlock value out of that business, and that's how you're going to make the IPO or the listing work for you. So to apply a percentage of the capital raised, I know that in a banking corporate world, where you enter into a transaction, there's some sort of retainer formula for that. Where you're talking about professionals in a listing like financial accountants and lawyers, we don't tend to apply that percentage formula or a success factor to it. So it reverts back to the time. So I think indications can be given of time, and then that can be factored in as a percentage of the value of the IPO. But I don't think that should be the only consideration. Cost should not be a consideration, because an IPO is for growth, is for the future, is to grow into something bigger.
I think the other point on costs is that those are fully disclosed and required to be disclosed in the prospectus. So there's full transparency as to what those costs are. There was a question up in the front.
Just to add on to the
Sorry,
thing that
Doctor, before the question.
costs are actually deducted from the proceeds of the funds raised. In other words, partly why they're actually disclosed in the prospectus is because you're telling potential investors that these costs are going to come out of the funding that is raised. So that's also usually important to appreciate. You're not going to take money out of your pocket to pay for fees, per se. They are going to come, that funding is going to come from the proceeds of the IPO if the IPO is successful.
My question is directed to Rem Molai, presentation he gave earlier on, which was very insightful on the rules, the regulations, the listing process. He mentioned some very key principles: openness, price discovery, fairness, transparency, something along those lines. And to me, those are the bedrock of the stock exchange, why it exists. So my question is around openness. Why did the stock exchange approve the BTCL listing with the restrictions that came with it? The condition that the shares were only available to citizens of Botswana and not to those who are non-citizens. Please just link that with openness for me. Thank you.
Mr. Siboni, I think I made it clear that I don't make these decisions. That was made by the main committee. But just briefly, perhaps I'll also ask my colleagues to also add to that. But I think it also had to do with part of the strategy of the Botswana Stock Exchange is to work hand in hand with government to develop this market. And because you find that with respect to BTC, for example, it was a company which was being sold by the shareholder, at least a part of it, to the market, and that shareholder has specific interests in terms of what he wants to achieve with that particular company. And it is a very significant shareholder, as you'll understand, the government of this country. So if, as with any applicant who applies to the stock exchange to list their company, you have the right, I suppose, to make an application to the committee and say, I want a waiver against such and such requirement. And you are absolutely right. One of the key principles, as you alluded to, is the fact that shares must be freely tradable. And so the applicant did make an application to the committee, and it was the BSC's decision to give that waiver with respect to only allowing citizens to have ownership of this of BTCL. So yes, I think without going too much into it, or without really not being in a position to defend that decision, my opinion, my personal opinion is that it has to do with the fact that the stock exchange is trying to promote the market, is trying to get additional listings, and therefore, if privatization comes with certain conditions, then the committee of the stock exchange has to work within those preconditions.
Thank you. I just want to add just one point, if I may, and it's necessary to do so. Martinez, I think it's a very important question, and because this is a public forum, it needs to be responded to. I think, you mentioned openness, transparency, and so on. I think it has been made fundamentally clear in relation to that particular IPO that there will be a citizenship restriction. So that's the transparency. It's there up front. It's not the case that was something which was promulgated halfway through the process. It's been there from day one. It's been there throughout the process, and it's there at the end of that process. So I would respectfully disagree with you if you were to say it wasn't transparent. But I think Mr. Tseola would like to add something to that.
Yeah, I just wanted to give it a little bit of perspective for some of us who spend a lot of time studying these markets. It's not only peculiar to Botswana. It happens also in other markets. In Mauritius, sugar plantations have got certain restrictions for listed companies. It's only the citizens who can buy this. I can also go next door to talk about BEE shares to an extent that the JSE has actually created a platform for BEE, Black Economic Empowerment. So you can only buy when you are black. So that is the restriction that I'm talking about. And a whole lot of other stock exchanges in countries. So we know very well that, yes, of course, it have got some level of impediment in terms of other people participating. But it happens in other countries. For me, I take it is the step in the right direction. At least we are happy the first privatization have happened. And going forward, possibly the restriction will be removed. Thank you.
I think we should also add that thousands upon thousands of Botswana retail investors have answered the call. I think that's a fundamentally important thing in terms of the development of this exchange. Any further questions?
Thanks,
Mr. Masunga?
Desai. This is Anthony Masunga from BTCL. I think you have done justice to question from Rasiboni, so I won't beat it to death. My question is aligned to what in the transport industry. We all know him now. Resabelo asked a really, really pertinent question, which I think needs to be addressed. And if I were to paraphrase it again, if I look at the panel there, it's quite a number of distinct entities. And I'm a company, family owned. I've built it for many, many years. And I'd like to expand it or take it to another level. And when I see 5 distinct or so functions, I really get scared. So the question that I want to ask maybe to you, Desai, is that how do I simplify this process or the process of interaction with these advisors? Because granted, the process is highly technical, it's highly complex, but the fundamental question is that how do we really make it simple for my company? Well, there's the issue of cost, which can be managed and negotiated, I like to believe. But how do we simplify it for the many companies out there that would like to come on board? And Red already did mention that we have about 20 companies, I think 22, that are now on the stock exchange. He'd like to have more companies coming on board. But when we see 3, 4, 5 advisors, we really get scared. So if you can just help us with that. The second bit that I would like to also add on to maybe learning from the gentleman from Zambia, the issue of really corporate governance, and maybe speaking to the issue of BTCL. As much as there's governance around bringing a company to the BSE and keeping it there, the BTCL one is a little bit more complex in the sense that there was added governance because this is a government-owned entity. So as much as we had to do to comply with BSE rules, we also had to go through the government process of actually ensuring that this is done above board. So it's not necessarily a good benchmark for a private company or an SME that would like to list. Thank you.
Thank you, Mr. Masunga. You want me to answer both? Okay, thanks. So the first one is how do we simplify the process? I think that I'll answer that in two parts. The first part of that is that, this very forum, as I think one of the panelists in the earlier session indicated, this very forum is part and parcel of explaining and therefore hopefully simplifying the myth or, unraveling some of the complexity to an IPO, right? So we would look, I think, collectively as the business community, including the entrepreneurial community, to the Botswana Stock Exchange and its education programs. And hopefully, by virtue of that process, it will become maybe not simpler, maybe not easier, but perhaps more understandable as to what is necessary, what the key components are. With regard to the various disciplines, and I say these are necessary offices. It's not necessary that the people who are sitting here or standing here are the only people who can do it, but these offices are necessary. The office of a lawyer, the office of a financial advisor, a transfer secretary, sponsoring broker. You cannot do a listing without those. Now, we've heard from Remolai about perhaps some other alternative boards that we could perhaps, working within the context of and with the help of the Botswana Stock Exchange, get to a position where the, young entrepreneur or an entrepreneur can work out whether it's the right time for him or her to take his company to a listing. So I think that's really, I guess, the best that can be done in relation to a complex process. It's like, if you go for complex surgery, that's what you're going for, right? You can't avoid it. If you're going for a heart bypass surgery, that's what you need to have. So if you go for a listing, this is what needs to happen. And then I think your second question was more of an observation. I didn't pick up a question in there. It's okay. All right. I think I've just been indicated this. Is there time for one more question? There's some excited people up there. Hey, to wrap up.
Good day. Yes, sir. My name is Godfrey Ranitz. I'm from the Sunday Standard newspapers.
Yeah.
Do you think companies in Botswana are ready for listing in the BSE, considering the processes and the costs involved? The other thing, with regard to the issue of costs, while it's not really clear how much it costs, I'm sure that you have partaken in a number of IPOs yourselves and some of the gentlemen involved there. Would you share maybe the cost involved in maybe one or two of those? Thank you.
Okay, so I don't think it's correct to say Botswana companies are not ready for listing. I mean, we've seen there are 22 which are listed on the main board. With regard to the cost, I mean, if one goes, it's public knowledge, it's in the prospectus. I think the cost of, I don't know, Max, maybe you can help me with the BTC IPO, it's about 13 million pula or something?
In the region of that, yeah.
And that's a very sophisticated listing on the main board. So, there will be varying costs around that. But hopefully that answers the question. And I'm directed to wrap up the proceedings. So I think, as I said earlier, hopefully we've conveyed some element of the role of the advisor. I think it's critical to note that you do need these advisors for an IPO on the Botswana Stock Exchange. So let me thank the panelists for their time, and thank you very much for listening to us and for your questions.